So welcome again, and thanks for joining us. My name is Karen Corman, and I have the privilege of being the Executive Director of the UIC Alumni Association. Welcome to the UIC Alumni Exchange Series. Through our Alumni Exchange Series, we work to bring our alumni and friends a variety of programs and topics so you can explore, connect, and sometimes even escape from the everyday with a community of UIC alumni, faculty, and staff experts. You'll hear me say this a few times today, but I encourage you to visit go.uic.edu/alumni exchange for the latest and greatest programming. And with that, I'm so pleased to begin our program today as we are joined by one of our favorite alumni exchange speakers, UIC law professor Steve Schwinn. As a constitutional law expert, Professor Schwinn is here today to talk to us about some of the most recent Supreme Court changes, including abortion rights, our liberties, and guns. Thank you so much, Professor Schwinn. That all came together. Sorry. Thank you so much, Professor Schwinn, for being with us today to talk through these changes and what they mean for the future and more. I'll turn it over to you.
Karen, thank you. It's really my pleasure. Before we get going, let's just do a sound check, and maybe if I can get a thumbs up from those of you with your cameras on. Can you hear me okay? Yep. Awesome. All right. Video's okay? No problems? All right. If you have technical problems, would you please drop a note in chat, and we'll try to take care of it as quickly as we can. I am going to ask if you don't mind turning on your cameras. I would love to see your beautiful faces this afternoon. That's great. It is such a pleasure and honor to be with you all. What a delight to do this again. I love these exchanges. It's great to see some familiar faces and returners, and very happy to talk to you today about the Supreme Court. So my name is Steve Schwinn. I teach law at UIC Law. I teach constitutional law, human rights, and comparative constitutional law. And Karen has been generous enough to invite me back now. I think we've done at least a couple of these, right? And I think while I have the floor, I'm going to go ahead and plug our next one, which is scheduled for next month with Dick Simpson, professor of political science. He's going to be talking about his book. Dick is retiring. He's been around Illinois and Chicago politics forever. He's an institution in Chicago, and his retirement is going to be a great loss for the UIC community. And for me personally, I adore the man and can't wait to moderate this event in September from the Union League Club for those of you that can attend in person, or on Zoom if you can't. So I hope you'll register for that and stay tuned for more. Okay, I think we can go ahead and get started. Karen, I do want to thank you, Karen, Jessica, Wendy, and Chris, and the whole team at Alumni. You all do just such a fantastic job with these exchanges and with everything else. And again, it's a real pleasure and delight and just a true honor to be with you today. I really appreciate the opportunity to talk about such important things going on at the Supreme Court. And I just really cannot emphasize that such important things. I was telling the group before we opened it up that I had my first classes yesterday, my first con law class of the semester. And I told my students, look, there really is no more exciting and thrilling time to study constitutional law. This may not be a stretch. In our country's history, there may not be a more exciting time to study constitutional law. The changes that we saw this summer are seismic. They're monumental. I simply cannot describe them with enough superlatives. And we've only started with this court. We're going to see monumental and seismic changes like this every term for the next decades if the court stays as it is, as is likely moving forward. And so I want to talk to you about some of those seismic changes that we've seen this summer, what we're likely to see going forward, and why. What's going on at the Supreme Court? I'll go ahead and get started. Before I do, I just want to reiterate what Karen had said earlier. If you have questions or comments along the way, I hope you please feel free to drop them in the chat. I'll try to keep my eye out. Karen and others will keep their eye out as well, and we'll try to address them as soon as we can. If you'd like to wait until the end, I will try to reserve some time at the end for Q&A as well. We have about an hour today, and I think my watch is saying 10 after. So we'll try to reserve a couple of minutes at the end, although I gotta say, Whew, so much to say about the Supreme Court this term. We could go on for hours, days, weeks, months, or years, as I think we probably will. So changes at the Supreme Court this summer. First off, one big change on the court, the addition of Justice Katanji Brown Jackson. This is thrilling and exciting. The first Black woman to sit on the Supreme Court, replacing Justice Breyer, a personal fan of mine, but I gotta tell you, as a con law specialist and watcher of the court, I simply cannot wait to see this court operate with Justice Katanji Brown Jackson, what she's going to add to the court, the perspectives and diversity that she'll bring to the court. Very, very exciting. And I gotta say, after our country's history, it's about time that we have a Black woman on the Supreme Court. And so I'm thrilled to see that change, and very excited to see what happens with the court going forward. So the court. Three big things happened at the court, and we tried to title this this talk in order to attract as much attention as we can. Abortion, gun rights, religion. Who can resist, right? And just in case you could resist, we added this, and more. Abortion, gun rights, religion, and more. So we have a lot to talk about today, but the big three cases that came down this summer dealt with abortion, gun rights, and religion. And just the quick sketch of these. The court, as you know, overturned the 50-year right, fundamental right to abortion in Roe versus Wade, a seismic change, a dramatic change. Never in our country's history have we seen the court roll back a fundamental right in the way that it did this summer. It truly, truly is stunning and a deep constitutional moment in our history. And as I said earlier, we've only just begun. I can say more about that in a few minutes. The next case, the gun rights case, expanded the Second Amendment, but also adopted a methodology with regard to the Second Amendment that I expect the court is going to use in Second Amendment cases going forward, but in other areas of constitutional law as well, in ways that will deeply affect our constitutional law, our constitutional values, our individual rights, and quite frankly, the way we relate to each other on a day-to-day basis. And then finally, the religion cases this term. There were two key cases on religion this term. I'll talk about one of them today, but these are on a trend. The way I describe it to my students is they're on a trend line to expand the free exercise clause, that is, enhance our opportunities to freely exercise our religion as against government intrusion, while at the same time contracting the establishment clause, that clause that says the government cannot establish religion. And between those two trends, the expansion of free exercise and the contraction of the establishment clause, what we can expect is that religion may and indeed must play a much greater role in our society than it ever has. To the extent that there's ever been a wall of separation between church and state, the Supreme Court has all but dismantled it. And I fully expect in coming terms that it will entirely dismantle it. Now, I just want to pause here for a second. With these seismic changes and turns that we've seen at the court this summer, again, it's impossible to overstate how significant they are. And what I tell my students is, look, these didn't fall from the sky, right? These were the results of a decades-long effort of advocates and instigators to put these issues before a court and to compose a Supreme Court that would be favorable to these issues, to overturn Roe versus Wade, to expand gun rights, to expand religion rights, to limit the administrative state, which is another significant ruling that came down this summer, and more. Now, we can appreciate those changes and like them, or we can not appreciate them and dislike them, right? But here's the thing. Again, these are the result of a long political effort, a sustained, carefully calibrated political effort by people and organizations who wanted to put these issues before the court to get the results that they got this summer and are likely to get in future terms. If you like the results that we got this summer, that's great. More power to you. That political campaign was successful to get us to where we are at this constitutional moment, and you should celebrate and reflect on the political victory that got us to this moment. But here's the thing. If you don't like where we are, you might be discouraged, and I get that. I share your discouragement. You might be discouraged and you might think, well, what's the point of any of this? But again, advocates waged a campaign to get us to this point. If you don't like where we are, we can wage a campaign to undo it and go back and expand rights and change the way that we relate to each other in our constitutional system. And so I think there's hope, whatever happens, whatever your view is, what happened at the court this summer, there's hope. And what it tells us is that the Supreme Court and our constitutional law is as susceptible of political change as ordinary politics when we elect members to our state to our state legislature, to our Congress, or elect governors or the president. Anyway, that's just my little plug for constitutional hope among all these changes. And let's go ahead and talk. So 3 big cases that came down this summer. I briefly described them in a second. And I got to say, in any term of the court before this, any one of those cases would have been huge. All 3 of them coming in the same term. And again, there were other cases that were similarly huge. Just makes this an incredible term, a really unusual, extraordinary term of the Supreme Court. Now, the cases themselves individually are hugely significant. Again, I can't really overstate how significant they are. But what the court did in these cases is equally significant. And here, I want to introduce these ideas to you now, and then see the trend line as we talk through these cases, what's going on with the court's methodology in making these decisions. And so I want to start here. So much of constitutional law is not in the text of the Constitution, right? It's Supreme Court interpretation. And when we deal with individual rights under the Constitution, say free speech or equal protection rights under the Constitution, the Supreme Court over time has designed tests that it uses to measure when the government intrudes on things like free speech or when the government violates principles like equal protection. These tests have been on the books for a long, long time. The court refines them from time to time, takes them in slightly different directions. But the tests really are the bedrock of our constitutional law, these Supreme Court designed tests that operate, excuse me, on a rights by rights basis under our Constitution. Let me give you a couple of examples. So when the government discriminates by race, for example, the government discriminates by race, and we call that an equal protection problem, the Supreme Court applies a test that we call strict scrutiny. What strict scrutiny says is that the government has an obligation. When it discriminates by race, the government has an obligation to show that it has a compelling reason to discriminate by race. That is, a reason of the highest order to discriminate by race, and that its racial discrimination is necessary to achieve that compelling government interest. What strict scrutiny means is, something on the order of 99% of government racial discrimination is going to fail, is going to violate equal protection. That's a strict scrutiny test. Now, we see other tests operate in other areas of constitutional law. And so, for example, if the government is regulating the economy, we often apply a test called rational basis review. What that means is that a government regulation of the economy will be upheld by the court against a constitutional challenge if the government can articulate any legitimate reason for doing what it's doing, any reason under the sun. And what that test means is that most economic regulation by the government will be upheld as against a constitutional challenge. Now, those are just 2 examples. There are scores of examples across constitutional law. But my point is that outside of the text of the Constitution, the Supreme Court has designed these tests that correspond to individual rights and carefully tailored these tests in order to assess whether the government is violating individual rights in particular contexts. Well, this summer, we saw the Supreme Court in 3 key areas throw those tests right out the window. What the court did was say, we're no longer using the test that we had established for abortion under Roe versus Wade and a case called Planned Parenthood versus Casey. We're no longer using the test that the lower courts have developed over years and years to measure government violations of Second Amendment rights. And we're no longer using tests that we've used for a long, long time in the religion clauses. Instead, what the court is doing is replacing those long held, again, bedrock tests in constitutional law with what it calls an historical approach. The historical approach in these cases, and likely in other cases as well as we move forward, means that the court is going to look back at our history to determine whether a government action today is constitutional or not. Now, let me just say a bit about this before I tell you what I think is going to be the court's historical approach moving forward, given its rulings this summer. So, historically, history has been a really important part of constitutional law. We always look at our country's history and tradition in measuring things like constitutional rights, even in measuring things like congressional authority or separation of powers, or whether, just to choose something completely randomly, whether the government can go into a private home to take papers that a government employee had taken from the Oval Office. Things like that. We always look at history and tradition, but we don't only look at history and tradition. And there are good reasons why. History and tradition is often contested. It's never determinate. Different people have different visions of the exact same history and tradition. And of course, history and tradition doesn't always fit with the contemporary issues in modern society. And so history and tradition is an important starting point, but it's not the end point. We also look at the text itself of the Constitution. We look at precedent, judicial precedent. We also look at what we as a people have done in the past, a kind of what I tell my students as practice as precedent. We also look at normative questions, ethical issues, how should we interpret the Constitution, and a number of other sources. In other words, historically, we've looked at a variety of sources in interpreting the Constitution. What the Supreme Court told us this summer is that from here on out, it looks like the historical approach is going to be not just the predominant approach, but the only approach. Now, the court's historical approach here comes really in two parts. You might have heard of a term called originalism. Originalism refers to the original understanding of the text of the Constitution. And some jurists say we ought to interpret the original Constitution based on the original understanding. We can discern the original understanding by looking at things like dictionary definitions at or around the time of the founding of the country, or at or around the time of the adoption of the Reconstruction Amendments 13, 14, and 15 in the late 19th century. We can also look at correspondence and other kinds of writings, how these terms, how these phrases were used at the time. We can look at ratification debates. We can look at the constitutional committee itself and the debates that it had to discern the meaning of these terms and understanding of these terms at the time. That's originalism, and that's one piece of this historical approach. But there's an important second piece of the historical approach that the court is using in these cases this summer, and that is looking at our history and tradition going all the way back to English common law, indeed going all the way back in some cases to the 13th century, and then tracing that history and tradition up through the colonial period, the revolutionary period, the early state period, early 19th century, the Reconstruction period, and into modern times. So the historical approach looks like it will kind of follow along two lines. This originalism, looking at the original understanding of the text of the Constitution, but then also a kind of tradition approach. What have we done? What has our legal tradition done over time? But here's the thing. The way the court has interpreted history in these cases is incredibly selective. It's taken a particular view of history. And the way that it's done that is that it has picked certain sources that it will rely upon and discarded other sources. And it's done that in a very selective way. It's interpreted those sources in a particular way and not in a different particular way. In other words, it's made political choices in the sources that it's selecting and the way that it's interpreting those sources in order to achieve the results that it seeks to achieve. Now that gives me, as a constitutional law teacher, I got to tell you, it gives me a big headache. And here's why. I really have no idea what the constitutional law is going to be in any area moving forward, because I really don't know how the court's going to interpret the history of any particular right moving forward. And so, what I tell my students, I told them this just yesterday, I know y'all have a lot of really good questions about what is the state of constitutional law, everything from free speech to equal protection to religion to abortion to gun rights. What's the law? The answer, I don't really know at this point. And that is largely the consensus of us in the constitutional law world who pay attention to these kinds of things. Indeed, I told my students an anecdote in class the other day that when these cases started coming down this summer, students who graduate from law school in their first summer typically sit for the bar exam. Well, the bar examiners had to send a special note to bar exam takers this summer saying, we know that there are a lot of shifts in constitutional law based on what the Supreme Court is doing. Don't worry, we're going to test you on the old stuff, not the new stuff. And it's kind of a silly anecdote, but that's just how radically changed things are today, as opposed to the way that they were just 3 months ago. All right, so let's talk about these. And I think we should start with abortion. The abortion case went to the Supreme Court, overturned Roe versus Wade. We all know that, but let me tell you a little bit more about the case itself. This was a case out of Mississippi, and it was one of scores of cases by different states that were trying to tee up an issue, tee up a case to the Supreme Court, specifically to get Roe versus Wade overturned. This, again, has been a decades-long litigation effort. It's been a decades-long political effort, as we know, to get Roe versus Wade overturned, just looking for the right composition on the Supreme Court in order to get just the right case before them to overturn Roe versus Wade. And this summer, it happened. The case came out of Mississippi. It was a ban on abortion, a flat ban on abortion after 15 weeks of pregnancy. Why is that significant? Well, the reason why is because under Roe versus Wade and Planned Parenthood versus Casey, the Supreme Court said that a woman has a fundamental right to an abortion up to the point of fetal viability. Now, fetal viability usually occurs around week 22 to 24 of the pregnancy. 15 weeks into the pregnancy is obviously before 22 to 24 weeks in the pregnancy. And so Mississippi's flat ban on abortion meant that women couldn't exercise their fundamental right to an abortion between that 15-week period and the point of viability. It was during that period that the opponents of the abortion ban said that the ban violated the fundamental right to an abortion and must be struck. Mississippi and many states and other advocates, on the other hand, argued that Roe versus Wade ought to be overturned. Well, the court overturned Roe versus Wade. The court said that Roe versus Wade was wrong when it was decided, and it was wrong today. The court purported to apply principles of stare decisis, which as a general matter say that the court needs to respect its own precedent. But what the court said is we don't need to respect Roe versus Wade for a number of reasons. One is it was wrong. Two, it created a kind of confusing framework that led to widespread confusion in the lower courts and in the states who were seeking to regulate abortion. And then three, oddly, it said nobody has relied on the right to abortion the way we need people to rely on a fundamental right or on a case in order not to overturn it. And I just want to say a quick word on that because the court's reasoning here was just so, it's still hard for me to get my head around. What the court said was because pregnancies where women seek abortions are by definition unexpected pregnancies, okay? The court said, therefore, no woman who seeks an abortion is relying on the right to abortion to get an abortion. In other words, a woman who seeks an abortion didn't come to that point in her life thinking that she could rely on the right to an abortion. It strikes me as a very odd way of looking at this, considering the fact that our society has structured it, everything, our social interactions, our economy, our healthcare, around the fundamental right to an abortion. The court said, no, we'll have none of that. What we need to look at is whether an individual person who's seeking an abortion was relying on Roe versus Wade. The court said, of course, they weren't, because they came to that point in their life unexpectedly. What I want to talk to you a little bit more about, though, is the historical approach that the court used in Roe versus Wade. So previously in abortion, the court had applied a test that we call the undue burden test. Here's how it operated. Before the point of viability, a woman has a fundamental right to an abortion, but the state can regulate abortion so long as it doesn't create an undue burden on a woman's right to obtain an abortion. That's one of these many tests that I had mentioned earlier that the court created and applied especially to the abortion context, because it balanced and weighed a number of different factors that play into the abortion context and came out and said, look, what we think the right answer for testing the fundamental right to abortion is undue burden. Does the state impose an undue burden on a woman's right to an abortion? If so, the state action is invalid. If not, the action is valid. So that was the test pre-viability. Post-viability, the Supreme Court said a woman doesn't have a fundamental right to an abortion after the point of viability, and therefore the state can go so far as to ban abortion entirely after viability, so long as the state provides an exception for the life or health of the woman. The exception is really, really important, right? Because post-viability, as we know, a number of women experience complications with their pregnancy that can threaten their health or their life. And so the court was careful to provide this exception as a matter of constitutional law. What the Supreme Court said in the case this summer, Dobbs, was that's all wrong. The court got it wrong. The undue burden test is unworkable, the court said. The lower courts have had a hard time applying it because they don't really know what an undue burden is, despite the fact that the Supreme Court has been pretty crystal clear about what an undue burden is. And they said it's wrong as an historical matter. Where the court erred in Roe and in Casey is that instead of applying a fundamental rights framework, what the court should have applied is this historical test that I had talked about. What the court said was, we need to look at our history and tradition, originalism and our legal traditions to determine whether abortion is a fundamental right. And so it traced government regulation of abortion going all the way back to English common law, through the colonial period, through the revolutionary period, through the early state period, the 19th century, the 20th century, and said there is no fundamental right to an abortion. Now, there's a lot to take issue with in the court's historical analysis. You know, law offices and judges' chambers famously make awful historical analysis. The judges just really are lousy at history. They're not trained to do it. They don't know how to do it. And as I mentioned earlier, they tend to do it selectively with a particular result in mind. And I fear that's exactly what happened in the Dobbs decision. I'm going to give you just an example of this. One of the things that the court pointed to was a kind of trend in state regulation in mid-19th century, where states were regulating abortion after quickening, so-called quickening. Quickening is the point where a woman can feel the fetus move in her womb. And so states were regulating abortion after that point. Now, it turns out there are a lot of interesting and historical reasons why states were on a tear to regulate abortion post-quickening, having to do with midwives' roles in the birthing process and the male-dominated medical field wanting to assert itself into that process, and so therefore banning abortion. But what struck me as really interesting and troubling, frankly, about the court's analysis is that Justice Alito for the court said the fact that states are banning abortion post-quickening says that states can ban abortion, period. In other words, he didn't say states are banning abortion post-quickening. And what that means is that states are respecting a woman's right to abortion before quickening, right? That seems like a plausible understanding of a state regulation that bans abortion post-quickening, but he didn't say that. What he said was, states are banning abortion, period. And as to that period before quickening, he said something very interesting and quite frankly, deeply troubling as well. What he said is, look, we know that states were banning abortion post-quickening and allowing abortion pre-quickening. But he said that doesn't really matter because there's nothing in the historical record that says that states couldn't have banned abortion pre-quickening. Wow, that's the kind of history that we're dealing with now from this Supreme Court that I'm afraid is really not history at all. And a good number of historians agree. And what I tell my students is, look, I understand we have different ethical commitments about abortion. Some people favor a right to abortion, other people oppose it. I think we can even disagree around the constitutionality of abortion and have a reasonable debate about that. But can we really have a reasonable debate about history when we're interpreting history in this apparently loaded way? And so this is where we seem to be. Now, this has all kinds of implications for other fundamental rights that fall in the family of fundamental rights of abortion, things like the right to marry a person of the same sex, the right to engage in adult consensual sexual behavior, the right to contraception, the right to marry somebody of a different race, even things like the right to parent and raise your children the way you want to. All of those rights that I just mentioned fall into the general family of rights that the right to abortion previously fell into, and all of those rights are now at issue under the court's methodology based on history. You can imagine that our country's history does not protect. When we go all the way back to English common law, do we really protect contraception? Do we really protect same-sex marriage, right? Do we really protect adult consensual sexual behavior, that is sodomy? This court's interpretation, by this court's reckoning, I think the answer to those questions is likely going to be no. And so replacing the context-specific tests with the history tests, I think, in coming years and decades is likely to mean that the court walks back a number of different rights that we have heretofore held fundamental and really, again, sort of based our society, our economy, our politics, our social relations around. I'm going to pause here for a second and see if anybody has any questions or comments about the Dobbs case and abortion. And if not, then we can go ahead and talk about guns.
Thank you, Professor Schwinn. We did have a question come in, which is, how is it that during the congressional hearings, Judges Kavanaugh and Barrett both stated that Roe versus Wade was established law or settled precedent, and yet voted it down as soon as it came up?
What a fantastic question. Thank you so very much for that. The question is, we know that justices that are sitting on the court, and we've talked about Barrett and Kavanaugh, but we could add Gorsuch to that, and even Chief Justice Roberts and Alito to this. In fact, every justice on the Supreme Court has testified, when they testified to the Senate Judiciary Committee in their confirmation hearings, that Roe versus Wade is settled law. Here's how I've always interpreted that statement. These justices are telling us, empirically speaking, as a positive matter, Roe versus Wade is settled law. But that says nothing about whether they would overturn it. Here's the thing. Under principles of stare decisis, the court can overturn its own prior cases if their own cases were wrongly decided, if they have not led to a kind of deeply embedded reliance interest, if they have proved problematic because of changes in society or changes in the economy or changes in medicine, for example. Those kinds of things the court can consider in overturning a prior case, even a case 50 years old that establishes a fundamental right like Roe versus Wade. And so when we hear, for example, Justice Barrett testify to the Senate Judiciary Committee that Roe versus Wade is settled law, the way I heard that then and the way I understand her to think about it now is, yep, Roe versus Wade was settled law and it's subject to being overturned just like any other settled law is. So is there any accountability here? Not in that sense, although there are just a lot of really interesting ideas floating around in my world about how there could be accountability for a Supreme Court if we're dissatisfied with the direction that it seems to be moving, well beyond the traditional packing the court type plans. There actually are really some very creative solutions for holding the court to account that would involve things like stripping the court of its appellate jurisdiction, which Congress has the power to do. There's an interesting proposal to actually create more states, that Congress could create more states for the explicit purpose of amending the Constitution in order to prevent the Supreme Court from issuing more rulings of this nature. And so there are really some interesting ideas to hold the justices to account. But in terms of their testimony to the Senate Judiciary Committee, I'm afraid that's just not one, because the truth is they were being honest when they testified to this Senate Judiciary Committee. Misleading, to be sure, but honest. Thank you. That was a really good question. Shall we move on to guns? Let's do it. All right. Second Amendment case came out in New York this term. It's called Bruin, the B-R-U-E-N. The case involved a 100-year-old law in New York that required individuals who wanted to carry a weapon concealed. This is concealed carry, not open carry. If they wanted to carry a weapon concealed, they had to apply for a permit, and they had to demonstrate a special reason for wanting to carry the concealed weapon. Now, a special reason would be something like, I live in a very dangerous neighborhood, or my commute to work is especially threatening to me, or maybe I have reason to think that somebody in my friend group or family group or social acquaintances could be a threat to me, and so therefore I need this concealed carry permit. In other words, a person could apply for the permit, but you don't just get it by applying. You have to show this extra special reason for getting a permit. A couple of permit holders who actually had modified concealed carry permits brought a case to the Supreme Court, and what they alleged was this extra special reason requirement in the New York permitting law that violated the Second Amendment. It infringed on their right to bear arms for self-defense, which the Supreme Court has held now is a fundamental right under the Second Amendment. Now, to understand what the court did in this case, it's important to talk a little bit about what the court has done with the Second Amendment in recent times. There have been two rulings from the Supreme Court in the last 15 years, 20 years, where the Supreme Court has ruled on the Second Amendment and really set us on a kind of trajectory with Second Amendment jurisprudence. In the first case, the Supreme Court ruled that the Second Amendment does protect an individual right to bear arms in the home in that case. In the second case, the court extended that right so that it applies against state governments as well. That was a case that came right out of Illinois, in fact, involving a local ordinance that banned handguns in the home for self-defense. And the Supreme Court said, no, neither Congress nor state governments can ban guns in the home for self-defense under the Second Amendment. Now, those two cases were highly contested. The Supreme Court was fractured, deeply fractured in those two cases about the interpretation of the Second Amendment. But those who held that the Second Amendment protects an individual right to bear arms, they won the day in those two cases. And so we now know that an individual right to bear arms is a fundamental right in the Second Amendment in our Constitution. Now, fast forward to today. What's happened in the meantime is the lower courts have been dealing with scores of Second Amendment challenges to state and national gun registration laws, gun licensing laws, gun show laws, every manner of gun laws. And in the course of that, the lower courts have developed one of these tests that I've talked about that's specific to the Second Amendment. The way this test works is the court asks two questions. First, it asks whether government intrusion on the right to bear arms, whether it goes to the core of the Second Amendment right, that is, the core of the right to bear arms for self-defense. If it goes to the core of the fundamental right, then it's probably invalid. But if it doesn't go to the core of the fundamental right, then the court assesses the question using a kind of intermediate balancing test. We call it intermediate scrutiny, where the state has to come up with a substantial reason for its regulation. And the court varies that test a little bit depending on how close the state regulation comes to the core of the Second Amendment or how far away from that core the state regulation touches on gun rights. But nevertheless, the lower courts have been pretty successful in applying this test to gun regulations, upholding many, overturning many, and just kind of chugging along, as courts do, applying constitutional tests to this Second Amendment right that the court had identified in the two cases that I described. Now we come to the Bruin case. The Supreme Court abandons that test entirely, just as it abandoned the undue burden test in the abortion context. It now abandons this two-pronged test that the lower courts have developed in the Second Amendment context and replaces it with history and tradition. But again, it's a kind of loaded dice, history and tradition. It's highly selective. The court looks at particular material, but not other. And the material that it looks at, it reads with an eye toward reaching, quite frankly, reaching the result that it wants to reach. Just to give you a sense of this, after those two first cases came down from the Supreme Court, historians put their heads together and they said, look, we really have got to set the court right on its interpretation of history with the Second Amendment. There's not a long tradition in our law going all the way back to English common law. There simply is not a long tradition, these historians said, of carrying a firearm for self-defense. It's just not there. In fact, the tradition cuts exactly the other way. We actually have a long tradition of regulating firearms and using firearms only for militia purposes, organized militia purposes, not for self-defense, that the government has long regulated, going all the way back to the 13th century, long regulated firearms and open carry and concealed carry and firearms in the home and restricted firearms use for organized militia purposes. And so these historians put their heads together and they said, we really have to set the Supreme Court right on this. It's going off the rails. It's going in the wrong direction. And so the historians told that to the Supreme Court, and the court rejected those arguments. Again, it thought that it could do history better than the historians and came up with this, very sort of particularized history of gun regulation using an historical approach. Now, between the Dobbs ruling on abortion and the Second Amendment ruling, both of these cases are using this historical approach. And I say that, and I've broken it down as if it has some particular meaning, some determinacy, some sort of form that we can kind of get our heads around and understand. In truth, it doesn't at all. And this is what's frustrating to me as a constitutional scholar. I really have no idea how the court is interpreting history based on these two cases and how it's likely to interpret history in cases going forward. By all evidence, it appears to be interpreting history in exactly the opposite way that trained historians are interpreting history, and that worries me deeply. Lawyers are, again, famously do history very, very badly, but worse than that, if we even knew what the court was doing with its history, it would help us out, but we just don't. And so this historical approach will unfold in the years and decades to come, and we'll get a better sense of where the court's going with this in fundamental rights contexts and in the Second Amendment context in cases to come. For now, I got to tell you, again, as a teacher, it's just incredibly frustrating trying to teach my students this new historical approach that the court seems to be using without really understanding what it means, and without really saying that the court can understand what it means. And just on that point, I'll just mention, not only in the dissent in these cases, but in some of the concurrences in these cases, the justices are calling each other out for using and misusing history and opportunistically using history in ways that are specifically designed to achieve particular political results in our constitutional law. Quite frankly, it's really tough to make sense of what's going on with the court's historical approach. And that point takes me to the third set of cases that I'd like to talk about. The religion cases. Now, I told you that there were two, but I really want to talk about one, the praying football coach case. You might have heard about this. The praying football coach went on the media circuit and it just got a lot of attention for this. And so you might have heard about this case. There was a football coach who insisted that part of his religious practice was to pray at the 50-yard line after high school football games, public high school football games. The school district, because it was concerned that allowing the coach to pray on the 50-yard line after high school football games, afraid that that would violate the establishment clause, that would suggest that the school district supports the coach in praying at the 50-yard line, and indeed that the coach is encouraging and endorsing this religious prayer among players and other students at the school. The school district said, you can't do that anymore. Look, after the football game, coach, they said, you're still on the clock. You're responsible for the players for a period of time after the football game. And when you go onto the 50-yard line and you pray, that's encouraging your students to come along with you and pray. And it looks like the school and the school district are endorsing your religious prayer. And the school district said that's a violation of the establishment clause, or at least gives us what I like to think of as establishment worries in terms of the coach's behavior. And so the district said, you can't do that anymore. The coach did stop for a while, but then he went back with fury and got not only his team to pray with him, but the opposing teams to pray with him. And not only that, but also local media, local organizations, local people were swarming to the football fields to pray with this coach. And again, he went on a kind of nationwide media tour promoting this and trying to gin up support for his post-game prayers. What he claimed was that when the school district was punishing him for praying at the 50-yard line, telling him that he couldn't do it anymore, that violated his free exercise rights under the Constitution. Under the First Amendment, we have a free exercise of religion right, which means that we can freely exercise our religion and that the government can't intrude upon that. But again, that's going to be subject to a well-worn constitutional test that the Supreme Court has devised. In other words, this was one of those cases where the Establishment Clause in the First Amendment actually runs up against the Free Exercise Clause in the First Amendment. Historically, the Supreme Court has allowed the government some wiggle room between the Establishment Clause and the Free Exercise Clause when a case like this comes up. The court has said that there's a kind of play in the joints between the two clauses that would allow the government to either prohibit the prayer if it decided that it had a sufficiently strong anti-establishment interest, or to allow the prayer if it wanted to allow the coach to freely exercise the coach's religion. In other words, the government would have a choice here in that play in the joints between the Free Exercise Clause and the Establishment Clause. But in this case, and in a companion case this summer, the court seemed to close up that play in the joints. What it did again is expand the Free Exercise Clause, contract the Establishment Clause, and at the same time close up any play in the joints or any wiggle room between the two clauses. It just appears, quite frankly, not to be there anymore. And the court did this by, in a line of cases leading up to this term, deliberately expanding the Free Exercise Clause, and in this case, condensing the Establishment Clause. Here's how it did it. The court now, for about 20 years, has had a couple of different approaches to evaluating Establishment Clause claims. This is where the government is promoting religion, and somebody claims that that violates the Establishment Clause in the First Amendment. The court has used a number of different tests that I had mentioned before. And so, for example, the court has asked, well, does the government action look like the government is endorsing religion? If so, then that's a violation of the Establishment Clause. Or does it look like the government action is requiring people to participate in religion? If so, then that's a violation of the Establishment Clause. And there were a couple of other tests that the court used in these cases. What the court did in the praying football coach case, though, is just abandon these tests entirely. We're not using those tests anymore. The test that we're now going to use is, wait for it, history and tradition. The same thing. In the praying football coach case, the court didn't even bother to analyze history and tradition. It just mentioned history and tradition and then concluded that the state's anti-establishment interest was insufficient to overcome the football coach's free exercise interest in praying. End of analysis. There's nothing in the case about how to do a history and tradition analysis under the Establishment Clause. We simply don't know. Now, there have been dozens of cases in the last 20, 30 years that have relied on one of these tests that I mentioned under the Establishment Clause. Everything from whether a government employee can pray, for example, whether a school teacher can pray in front of students, to whether a government can set up a 10 Commandments monument in a public courthouse, things like that. Dozens of these cases, probably in the lower courts, hundreds of these cases over the last 20 or 30 years that have relied on one of these tests. And now we replace it with history and tradition without knowing what history and tradition is, what it means, or how the court's going to do that analysis. The court told us not one whit about that in the context of the Establishment Clause. And so I don't really know how to teach Establishment Clause at this point. I got a call from a reporter the other day who asked me, can a local school host a sectarian prayer for its teachers before the beginning of the school year? Well, before this term, I would have said, of course not. That's a flat violation of the Establishment Clause, any way you look at it. Today, I just don't know the answer. We'd have to look at history and tradition, but again, I don't know how the court's going to do that. And so this is, again, one of those areas where over the next years and decades, I expect that the court is going to be applying history and tradition, fleshing this test out and teaching us how it's going to apply it so that we have some guidance in future cases. I'm going to end on this. I think the court's work has just begun. In every area of constitutional law, and in particular, every area of individual rights, we rely on a test. These tests have long been with us. It looks like the court is replacing those tests with a history and tradition test. I'd mentioned earlier, when the government discriminates by race, the court applies strict scrutiny under the Equal Protection Clause. I don't know, but imagine that the court might replace that strict scrutiny with a history and tradition test. Do we have a history and tradition of things like racially segregated schools or interracial marriage? Well, I got to tell you, if you look back at the 19th century, most certainly we do not. And so we may be looking at an entirely new and different world moving forward, given the court's focus on history and tradition, and its likely focus on history and tradition in all areas of constitutional law. So I'm going to stop there. I don't know that I've left any time for questions. I'm sorry about that. I've been jabbing on too long, but if there are any questions, I'd be happy to take them, and happy to stay on longer if anybody would like to chat.
Well, thank you so much. This has been so incredibly informative. I did have a question about how could somebody get a recording, because you've shared so much great information. So if you are like me and you want to go back and absorb it even more, it is being recorded and will be available on our website. So we'll go ahead and put that link in the chat. You did have one question come in on the chat, and then I had one other question on the back end. The question in the chat was, so a Muslim inherently can roll out a prayer rug on the 50-yard line during a call to prayer?
So I had predicted this summer, before Bremerton came down, the praying football coach case, before that came down, I thought, I know the way the Supreme Court's going to rule in this case. I don't know how they're going to get there, but I know they're going to rule for the praying football coach. And I also know that an immediate result of that this fall with high school football games is that everybody is going to rush to the 50-yard line to pray or not pray, depending on their political persuasion. And so I simply cannot wait to go to my own local high school football games and see the diversity of religions and non-religions on display at the 50-yard line after the game. And if they're not there, you can bet that this con law scholar will bring them there. Everything from, the big three to paganism to atheism to anything under the sun appears to be open. Now, I will say, this is one of those areas where the dice are loaded. This court is going to lean toward evangelical Christianity and protecting the free exercise rights of evangelical Christians. It's not going to protect other religious rights quite as openly and freely. And in fact, it might not protect them at all. So strap in. We're going to see what the court does with its free exercise jurisprudence, but I don't expect consistency across religions.
Sorry about that, I just lost camera. So you actually just answered another question that came in. So it's like you knew that one was coming, so thank you. I also had one last question, and this might be just a bit of a doozy, but with all of these changes and the continued changes with the Supreme Court, how would a person go about sort of continuing to read about this? Is there a certain reference or a source that you might say on a daily or weekly basis, go here for non-biased information, if you will, and just where can people continue to try and stay informed about everything that's happening if you're not in law school?
Excellent. Yes, thank you. And I just put my email in chat, so I welcome anybody to please feel free to drop me a note. I'd love to hear from you and connect and stay in touch around these issues or other issues. Where can you find more? So the go-to on this really is SCOTUS blog. Put that in the chat as well. SCOTUS blog has outstanding reporting on the Supreme Court and issues at the Supreme Court. My go-tos are not only SCOTUS blog, I devour the New York Times and Washington Post and Wall Street Journal to the extent that I have an opportunity. Bloomberg has excellent reporting on the Supreme Court as well. And I edit the Constitutional Law Prof blog that has gone a little dormant this summer as I start to rethink how I'm going to package that. But one of the things that I expect to roll out in the coming months is a new website that will have different interactive features on public education around constitutional issues, on individual rights, but also the structure of government. And so I'd welcome you to check that out as well. We'll share that with you through our networks and the next time I see you all.
Yes, please do. And I just want to echo many comments that are coming on the chat of just thank you so much. This has been so incredibly informative. And we're so grateful for your time. We're also very grateful that you are a professor in our law school and continue to educate our students and just bring your knowledge and expertise with us. So thank you so much, Professor Schwinn, for all of this. And we look forward to the next part. Somebody said, when's the next one coming? So we will continue to invite you back if you will continue to have us to continue these important conversations.
It's truly been my honor. Thank you to everybody. I just so appreciate this opportunity to engage with you. Thank you.
Well, thank you. And I'm going to end with how you began, which is a plug for our next alumni exchange program. Just to remind everybody that we'll be in front of a live audience. And the program will feature the College of Liberal Arts and Sciences Professor Emeritus Dick Simpson. And he will be presenting The Crisis in American Democracy Today. That will be on Monday. You heard me correctly. That is a Monday. We don't typically do alumni exchanges on a Monday. So we'll start our week off right. On Monday, September 19th at noon Central Time. You can go ahead and register for that program today. It's already online and you can sign up. And of course, we're very excited that Professor Schwinn will be moderating that conversation with Professor Simpson. So please join us on Monday, September 19th for the next exciting alumni exchange program. Thank you to all of you for joining us. Of course, you can find a recording of this episode and our past episodes at go.uic.edu/alumni exchange. And please be on the lookout for that brief survey that I mentioned at the beginning. Thank you again, Professor Schwinn. Thank you to all of you. We look forward to seeing you at a future alumni exchange program, and have a great rest of your day.